Hi, everyone. Welcome to the final webinar in our 2022 estate litigation series. If you happen to have missed our first two webinars in the series, please visit fasken.com, the Institute section, to access the recordings for those sessions. My name is Lily MacLeod. I am a Toronto associate in Fasken's Litigation and Dispute Resolution Group. My practice focuses on estate litigation, substitute decision-making, class actions, injunctions, and general commercial and civil litigation. I'm joined by my colleagues, Jonathan Lancaster, a Toronto partner in Fasken's Litigation Group with nearly 30 years of litigation experience. And John's practice focuses on estate litigation, corporate commercial litigation, commercial real estate litigation, lease arbitrations, banking law, product liability litigation, and professional negligence. I'm also joined by Karen Wyke, a Calgary partner and co-leader of Fasken's litigation group with over 20 years of experience, and also named by Benchmark Canada as one of Canada's top 100 women in litigation. Karen's practice focuses on complex commercial, construction, and contract litigation and arbitration, as well as estate litigation. We are very looking forward to discussing the issues today associated with dependent relief litigation. Our presentation today will cover Ontario law and Alberta law, and we'll cover the following topics. First of all, what is a dependent relief claim? Next, we'll talk about who can bring a claim. How do the Ontario and Alberta statutes define a dependent? Next, we'll take a look at, can a testator take proactive steps to protect her estate from a claim, including a discussion about cohabitation agreements. Next, we'll look at the nuts and bolts of a dependent relief claim. When these claims are commenced, what does it actually look like? How long does it take? And how does it impact the distribution of an estate? And finally, we'll talk about quantum of awards. How do courts decide how much dependents are entitled to receive as orders for support? Karen, can you, at a high level, tell us what is a dependent relief claim?
Sure. So before we get there, I'll just give a broad introduction, Lily, about claims against an estate. So if you tuned into our last presentation in the series, you might get the impression that there are a number of estate claims that can be asserted against an estate. And certainly there are some interpretation issues or trying to set aside a will for undue influence, that kind of thing. But across the country, generally, testamentary freedom is still paramount, and there are few ways to attack a distribution of an estate. The dependents relief legislation across the country is a statutory ability to challenge an estate. And one exception to the testamentary freedom, in BC, there is actually a broader ability to challenge the distribution of an estate under will's variation, and you don't necessarily need to qualify as a dependent. But with that exception, testamentary freedom is paramount, and these statutory claims of dependents are allowed across the country. There are a lot of policy reasons for that, the main one being that testators or deceased owe, the Supreme Court of Canada has found legal and moral obligations to adequately provide for their dependents so that the state does not have to provide for them. So that is how estates can be reallocated. The distribution of estates can be reallocated through these statutory claims. What we see as litigators is that the most common dependence claim on an estate is the scenario of a second wife and the adult children of the deceased. Or second wife or husband, I should say. And so we do see A lot of what we will call common law spouses, also known as adult interdependent partners or second spouses, bringing a claim against the estate where there has not been adequate provision. There's lots of issues, legal issues that come up in respect of these type of claims. The first being does the claimant qualify as a dependent? Has there been adequate provision? And in some cases, are there bars to recovery? This does highlight this limit on testamentary freedom, and the claims that we see highlights the importance of proactive estate planning, which we will get to later in the presentation. So next slide. So to your question, what is a dependence relief claim, Lily? It is a claim against an estate by a qualifying person, and that is generally a dependent. In Alberta, in the legislation, the dependents are defined as family members, and it's a claim for proper maintenance and support where a testator has failed to provide adequate provision, either through their will or in an intestacy. And where an application is successful, relief can include spousal support, a lump sum payment, and temporary access to a marital home. I should note here that there are some consequences for an unsuccessful claim. So just that gives pause to those who are making a claim, and also important for the estate to realize that. So next question, or next slide, thank you. Who qualifies as a dependent? And I think largely that depends which province you reside in. But just from a very broad perspective, as I mentioned, in Alberta, certain family members qualify or can qualify as a dependent. Spouses, definitely. And just a note there, you can be living separate and apart at the time of the testator's death and still qualify to bring an application for relief. You can be estranged as well. So spouses, adult interdependent partners, also known as a common law spouse in some provinces. And whether you're an adult interdependent partner will also vary depending on the provinces. We'll be getting to what some of the qualifications are to become an adult interdependent partner in Alberta. Minor children of the deceased, which can include the grandchildren, adopted children. There's less clarity in the law as to whether stepchildren qualify as a dependent, and some divided case law that will depend on whether the deceased occupied a position of what's called as acting in loco parentis, so sort of a settled intention. Similarly, to assume the responsibilities of parent. In Alberta, that is the same with the grandchildren of the deceased. Grandchildren don't necessarily qualify as a family member to bring an application unless there is a settled intention to act as that child's parent, essentially, or caregiver. Children over 18 can also apply, but in very limited circumstances. One, if the child is disabled by reason of mental or physical disability and unable to earn a livelihood. There has been some case law that if a child over 18 or a dependent over 18 qualifies for government assistance because of that disability, that is prima facie proof that they would be successful in establishing themselves as a dependent for the purposes of dependence relief legislation. A child over 18 may also qualify as a dependent if they are also between the ages of 18 and 22 and a full-time student. In Alberta, we've added parents, brothers and sisters, but those are not qualifying family members within the meaning of Alberta legislation. But it does highlight some of the differences across the country in the legislation. And again, just a note that under BC's wills variation legislation, there is a broader ability to bring an application to vary the distribution of the estate. Now, I think my colleagues are going to, my Ontario colleagues are going to talk about who qualifies as dependents in Ontario.
Thanks, Karen. That's very helpful. So as you say, this is a statutory claim and there's different legislation in different provinces. So in Ontario, Jonathan, what is the governing piece of legislation and how does that piece of legislation define dependent?
Yeah, so the legislation is called the Succession Law Reform Act, and it deals with all sorts of issues concerning wills and testamentary issues. And the Dependents Relief, what used to be called the Dependents Relief Act, is now just part of that statute. It's Part 5, and it's found in there. There are not a lot of differences between Ontario and Alberta, really, in terms of individuals who may qualify as a dependent. You can see this is virtually the same list. There'll be nuances in the differences of the test. We're going to come to the test in a moment. Just by way of an introductory and overview comment, a lot of people view dependents relief claim as people trying to change the will, and it's not. Conceptually, it's not that at all. If somebody establishes a claim as a dependent, they are a creditor of the estate. They're not a beneficiary, they're a creditor, and creditors get paid before beneficiaries. So I say a lot of family members say they're trying to change the will, defeat the intentions of the parents typically, but strictly speaking, that's not the case. Dependents relief legislation started in New Zealand, as many progressive ideas do. The idea was to keep dependents off the public purse, but we are long way from that now. When you see some of these claims and the sizes of the claims in relation to what are now very large estates. Third thing by way of an introductory comment is that the court does give some deference to what the testator has done. The Supreme Court of Canada said, look, there's a range of ways of providing adequate provision for dependent, and there's not one way. And as long as you're within the range, the Supreme Court of Canada says, don't disturb the will, don't disturb the testator's intention. So you don't have to get it exactly right, and the court will look at the overall circumstances. Having said that, well, that's the Supreme Court of Canada principle. A lot of the cases go right through that, and they get right down to I wouldn't say micromanaging, but they will change the estate if the facts are, in the judge's view, requiring some change. They won't tinker, but they will not hesitate to change if they think they're close to the outside of that deference. So as I said, just coming back to the slide, there's not a lot of difference between Ontario and Alberta in terms of who qualifies. Part of the test we should focus on here is the last bullet point, to whom the deceased was providing support or was under legal obligation to provide support immediately before his or her death. In Ontario, under the Family Law Act, a child has an obligation where able to support a parent. A parent has an obligation where able to support a child. So that's where the legal obligation comes from, even if there's not an agreement, and even if you haven't been providing support, you can still be fit within this legal definition because the Family Law Act requires that be done. Now, there are exceptions, and Karen had mentioned a few on the slide she had looked at in terms of particularly children once they get they leave the home, or they're out of leave parental guidance, or they're out of secondary education. So I think we'll go back to the moderator.
I think we can go to the next slide, please, and thank you. So specifically as it relates to, so the definition of dependent includes spouse in the Ontario legislation. So who is a spouse in Ontario, John?
Well, again, that's under you look to the Family Law Act, and you can see we've put it down on the screen here, and it's not just a formal marriage. You can see they together lived in a marriage that is down to Section 29. They've continuously been together for a period of not less than 3 years. And then they say at the bottom, you'll see the definition of cohabit means to live together in a conjugal relationship. There has to be some notion of living together, but it doesn't have to be permanently living together. The court looks at all of the circumstances in the cases. And one thing you'll learn from these cases is that they all turn on their own facts. You can extract some principles from them, but each case is trying to decide what's appropriate in the particular circumstances in front of the court.
And just before we move on, there are some sort of notable differences in the Alberta legislation in respect of how this is structured. I think ultimately the effect is the same. Our legislation specifically outlines a spouse, meaning a legally married couple. And spouses do not need to cohabitate at the time the application is brought, or at the time of determining whether there's been adequate provision. And then separately, adult interdependent partners are family members within the meaning of our legislation. And whether you're an adult interdependent partner is referable to the Adult Interdependent Partner Relationships Act. And our legislation, similar to the Ontario legislation, Jonathan, which has consolidated a lot of different legislation into one big Wills and Succession Act that now has a division of that act dealing with family or maintenance and support applications. There is a trend away from calling it relief, to your point earlier. It's legal entitlements and that kind of thing. So anyway, some different interesting differences in how the legislation is structured. And, back to when I'm thinking even to the earlier slide, there is no requirement written into our legislation that the deceased needs to be providing for the applicant at the time of his death. Now, I take your point that the legal obligation requirement in your legislation sort of waters down that provision, but there's specific cases in Alberta that say even estranged children can bring an application or estranged adult dependent children can bring an application as a qualifying family member, even where there has been no provision for support during the deceased lifetime. So some interesting differences technically, but I'm not sure. I think the case law seems to be developing the same way.
I just wanted to come back to the words that are highlighted at the top of this slide, where spouse includes individuals who are married to each other by a marriage that was terminated by divorce. I just want to highlight that in relation to a recent case in Ontario. It came out in 2021. The couple had divorced in 1994. The husband died in 2018. And in 2021, the spouse who was receiving periodic payments from the husband brought a claim for dependents relief, so that they had been divorced for many years. That claim was brought and it was allowed. And the interesting thing about the case was, and the reason why the case was allowed to proceed and the spouse did prevail, partly they were hard facts, because by the time the application was brought, the spouse was 94 and in a nursing home and needed nursing home money to survive in the nursing home. But in that particular case, there had been a lump sum payment as part of the settlement, but there were also periodic payments being made. And as the periodic payments were being made, the support obligation continued. Had there been a lump sum payment made in 1994 and that was it, and a release, the claim would not have been allowed to proceed. So if you're on the paying side of these, there's something to be said, if you can afford it, for doing a lump sum payment. The other interesting thing about the case is that the parties did have a release as part of their divorce, but the court said, number one, the release doesn't mention Succession Law Reform Act, so it didn't necessarily bar those claims. And in any event, certainly in Ontario, the court can look at an agreement. Agreements are important, but they're not overriding. They won't oust the court's jurisdiction. They'll be, depending on which case you read, they'll be given great weight, or the recent case I mentioned, not a great deal of weight. But that is something that when people are getting divorced, I'm sure the divorce lawyers know this now, but there are many old settlements where the releases didn't specifically attempt to exclude the Succession Law Reform Act and left the door open. And again, the other point is that if you're providing periodic support, then that's sufficient to establish dependency. And in this particular case, the periodic payments that the spouse was receiving increased by about fivefold. So 5 times more than they were getting under the periodic payments under the divorce settlement.
Okay, well, thank you for that, Jonathan. So, Karen, you talked a little bit about the Alberta legislation, but can you tell us what that legislation is called and how it defines dependent in Alberta?
Sure. So, as I mentioned earlier, Alberta's legislation specifically allows or defines family members and provides for spouses as well as adult interdependent partners, which is just a different term for common law spouses, I think. And it refers to an adult interdependent partner as defined in our governing legislation, which is the Adult Interdependent Relationships Act. And you know, there's you can be a common law spouse or adult interdependent partner for a variety of issues and claims and legal rights. And so that legislation has more universal application. So it has not been brought into the umbrella of this now overriding succession legislation. It is its own act. If you go to the next slide, there are really a number of factors to determine whether somebody is your adult interdependent partner. And these are some of them. This is the what defines an adult interdependent partner. So as you would imagine, the main qualification is that there's a relationship of interdependence. And then the question is, well, how do you establish what a relationship of interdependence is? The relationship has to be for a continuous period of 3 years or more, and that's living together. Or if there is a child of the relationship by birth or adoption, you don't have to have that relationship of interdependence for as long. And the other option would be where partners have entered into an adult interdependent partner agreement. And then there's relationship of interdependence also has some factors. It means a relationship outside marriage, formal marriage, in which any two persons share one another's lives, are emotionally committed to one another, and function as an economic and domestic unit. And so there are some factors in determining how you share one another's lives or are emotionally committed to one another. This is not an exhaustive list, but some of those factors include that there be a conjugal and exclusive relationship, that the partners hold themselves out as either a domestic or economic unit to socially and to people who meet them. There's a direct or indirect contribution to each other's mutual well-being. There's financial dependence or interdependence, and there's an examination of the ownership and use of property. The key consideration, of course, is the continuous living together for 3 years up to the date of death. There's been some developing case law on that, and at times the courts can be creative. We were debating a case earlier, the three of us, but didn't want to necessarily dive into all those details. But generally, that is the most important qualifier in Alberta to become a family member who is a qualifying applicant for maintenance and support. There is some, I spoke earlier that a former spouse can bring a claim as a spouse, and they can be living separate and apart. It is unclear whether a former adult interdependent partner, because of the requirement to be cohabitating continuously for 3 years up until the date of death, whether they can bring a claim. So we'll see. As we say, courts can get creative, but that seems to be a bit of a hole. There's lots of case law on establishing the sort of this threshold for becoming a family member. Even couples who keep separate finances but socially present as a couple with an exclusive conjugal relationship have found to be a couple or adult interdependent partner for the purposes of the legislation. So people can try to structure their affairs, and particularly those who are entering into maybe a relationship after the dissolution of a legal marriage and are trying to protect the distribution of their estate for their adult children from their first marriage. There's some issues there and legal obligations that are created. So we'll talk later about how you can protect that. So some of the recent case law on adult interdependent partner status in Alberta, a non-resident can be an adult interdependent partner, provided they satisfy the other factors stipulated in the Act. Where the next case, the Martin case, where common law spouses were essentially discontented or maybe emotionally estranged but had not terminated their relationship or taken steps to separate, there was still an adult interdependent partner status found in that case. Family law, there's lots of family law cases on living separate and apart, and couples can live separate and apart from one another in the same home, from my recollection, but there has to be steps taken to separate for the purposes of terminating that interdependent relationship. Next slide. This case, the Mitchell case, found that there could not be two adult interdependent partners at the same time. That seems to make sense from the definition under the legislation of what an adult interdependent partner is. There has to be exclusivity and holding out and a cohabitation. It's hard to do that with two people at the same time. Interestingly, though, you can, for the purposes of dependence relief or maintenance and support, I should correct myself with the right phraseology, you can have both a spouse and an adult interdependent partner who are making claims for adequate provision and support. You just cannot have two spouses because you can't be legally married to two people at the same time, and you cannot have two adult interdependent partners. Next case. And this case just sets out, what I was talking about earlier about integration of finances and that kind of thing. Was seen as establishing the interdependence that's required to be established in order to be a qualifying family member for the purposes of the Alberta legislation. Okay, next slide. Okay, so sorry, Lily, were you going to say something? Oh,
I just wanted to touch, if I could, briefly on the issue of exclusivity. Saw the Mitchell case there. I was actually just going to see if it had ever been applied in Ontario. I realized it only just came out this year. I'm not sure under the Ontario statute whether that's the test, given that we have a different test, and I don't know that exclusivity will be applied necessarily. I realize we have laws against polygamy, but these are statutory tests of that go to the issue of support under the Act. Certainly, you can have multiple spouses who are making concurrent claims: first spouse, second spouse, third spouse. Not concurrent; they're making claims in the sequence of the relationships. But it's also possible that you could have, for the purposes of the dependents relief legislation, multiple spouses. It would give rise to the issue of cohabitation continuously, but I think the cases have been created that on cohabiting continuously doesn't mean every day. It's a relationship of permanence. So I just highlight it as a possible difference between Ontario and Alberta.
Right. Thanks, Jonathan. Yeah, as you can see, the statutes are similar, but how they're applied in different provinces will be some nuances. So Karen, I mean,
Sorry, I put you off.
Karen, you've alluded to the fact that these disputes can be very emotionally charged, and as we'll talk about in a little bit, very time-consuming, expensive. So is there any way that a testator can take steps to protect his or her estate from these kind of claims?
Yeah, I mean, the best way to protect against it, and Jonathan will be touching on this later in his slides, is to make adequate support and provision for those who would qualify as dependents. That really is the best insulation. But there's people try to insulate themselves from these kinds of claims through what's known as an inter rerum clause in a will, and I'll get to what those are. There's also, in the case of spouses and adult interdependent partners, it's sort of the purpose of prenuptial and cohabitation agreements. We'll look at the efficacy of those as a protection. But as I say, the best protection against these kind of claims is making proper provision and support, and we'll canvass what that means, what adequate provision and support means. And I think, Jonathan, you had a point about fraudulent conveyance, which is a good.
Yeah, so one way, or you could say the best way previously to protect yourself was not to leave your assets until your death to dispose of them, because the court can intervene under the statute. There has to be a death. The court can intervene in respect of dispositions after death or upon death. So it's been done where people will say, well, I'll transfer my assets before death to make sure they don't have that problem. And that was one way of trying to deal with this. Under a different piece of legislation in Ontario called the Fraudulent Conveyances Act, if you transfer property with the intent of defeating claims of creditors and sometimes potential creditors, the court can undo those transactions. I'm not aware of any case where this has been tried yet, but I am aware of one case where the estate was transferred in that manner, and the attack on that transfer, the pre-death transfer, is that it was attempting to defeat the claim of a creditor, in this case, a child. And you can see how the court would take a particularly dim view of that. So we'll see whether that case gets to a decision or whether it resolves itself. But that is, say one way of doing it. Assets can be accumulated. There's nothing wrong with, assets being accumulated during a marriage, and they can be accumulated in the name of the spouse who's not subject to necessarily the dependents relief claim that the couple is worried about, typically from a previous spouse, but not always. And that's probably a legitimate way of doing it, that if the house is in the name of spouse number 2 because spouse number 1 had a previous spouse, that's probably okay. That's especially in many relationships where one spouse is exposed to creditors, professionals, as an example group. Typically, the other spouse will have title to the property. I suppose the other way of doing it is to make sure that if you are in a situation of separation or divorce, that you get a proper release that includes dependent relief claims, and the court will give those great weight, and as best as you can, try to do a lump sum settlement so there's no ongoing obligation.
Mm-hmm.
Great. I think we can go to the next slide.
Yes, we're going to examine, the different ways that you can attempt to insulate your estate from dependents' claims. One avenue that used to be attempted, not so much anymore, is through an interim clause in your estate. And actually, you still see them in wills all the time. And they can be great for all kinds of claims, but they don't really insulate an estate from a claim for maintenance and support by a dependent. So what is an interim clause? It's essentially what's known as a no contest clause. And essentially they say that if any beneficiary in this will attacks or disputes their bequest, they are essentially forfeit their bequest, and that bequest becomes part of the residue of the estate. I've seen interim clauses generally more challenged these days, and as a result, what you'll see is a watered down version of an interim clause. I don't know if you're seeing these, Jonathan. I know one case in which we've seen them, which says that instead of being disinherited, essentially, if you challenge the estate, you'll have to pay your own costs. Typically, costs of the challenge of an estate are borne by the estate itself, but you'll have to pay both the estate's costs and your own costs. So still waiting to see whether those interim clause will be held to be enforceable. As I say, they're not completely unenforceable, but for the purposes of dependent claims, they have been determined to be against public policy and void. Again, being that a deceased who owes a legal or moral obligation to support their dependents cannot essentially contract out of that obligation. And the courts will not them in the context of application for maintenance and proper provision. So
just on the, sorry, Karen, go ahead.
Yeah, go ahead.
I was just going to say, just on the costs clause in a will, it is meant to discourage litigation, and somebody looking at that and not knowing anything further about costs may be discouraged, but actually costs are in the discretion of the court, and the court can decide who gets costs regardless of any agreement or document otherwise. So you can put it in there and say it may discourage some people, but a litigation lawyer looking at that's going to say, well, the court will decide costs. An interim clause might be more stomachable to the court if it applied across the board to all challenges. But if it's just directed at a class of challenger, a dependent, whether ex-spouse or dissatisfied child, then it's more likely to be disregarded by the court as opposed to, say, applying across the board. And it's a matter of degree. Are they forfeiting everything, or is it just a reduction? So the court can look at it and balance that. Just one thing, in just going back to the notion of attempting to protect yourself, the court in Ontario will have regard under the Act to the wishes of the testator expressed in the will or outside of the will as to why they have left someone, a dependent, a certain amount or nothing. And if there's, could be a letter of wishes or just, why you've done that. It's not overriding, but the court will have regard for it, because oftentimes in a will, you don't see that narrative. In fact, you rarely ever see that sort of a narrative. But if it is reduced to writing, say the court will consider that as a factor.
It's a very good idea. If you're going to, I agree with you, Jonathan, if you're going to prefer children over another, I think an explanation that is an addenda to the will in some way is helpful. Of course, the will is always the testator's last opportunity to speak. And without that wishes, memorandum of wishes, or other document or addenda to the will, it's very difficult sometimes to, there's lots of rules about what's admissible as the testator's voice. And so formalizing something and including it in your will is a very important step in some way, because, as I say, that evidence of what a testator intended is typically limited to the will itself. So the next one, we're just going to look at, and next slide, sort of family agreements. And to Jonathan's point, they're generally given a lot of deference, or some deference, and considered by the courts always. They're not ironclad, and especially where an agreement would be considered to be unfair. And so really they're a very similar kind of agreement, prenuptial cohabitation. A prenuptial agreement typically applies in a legal marriage, and a cohabitation agreement applies in the case of common law spouses. There are, both in the context of family law and as well in the context of estate law, when dependents are making claims, there's a lot of questions which surround their enforceability. I don't intend to dive into those requirements in it with any specificity, but generally they relate to whether there's been adequate financial disclosure, or whether the agreement has been entered into under one party's duress. And it really goes again to the requirement for these agreements to be fair. Lots of spouses will argue, I was meant to sign this agreement within 2 days of our marriage. We see lots of case law on that. And I didn't have, I was under economic duress because I didn't have the same financial independence, or I signed the agreement not knowing what my rights were, or what my entitlements were, and also not knowing what my common law spouse's financial position was. So it's the same kind of arguments that are made to set aside any commercial agreement, and those opportunities for setting them aside are very limited. I would just say as a general note that it's easier to contract out of property distribution than spousal, and I think my colleagues will be diving into this a bit more when they examine the Tatterin case that is sort of the leading case on quantum and those kind of things. And then ultimately, and to Jonathan's point earlier, even in the face of these agreements, the court maintains ultimate discretion, particularly in relation to support. There is a strong moral obligation to support a spouse or an adult interdependent partner. That's what the case law in Alberta is saying. And so as Jonathan will take you through, a testator has both a moral and a legal obligation to support the spouse. So there's ways that the courts can sidestep an agreement that deals with a spouse's legal obligation through a family agreement, but the moral obligation does give them an opportunity to redistribute in a way that was not envisioned in any family agreement. So as we were saying, the best protection for insulating an estate or your estate from a claim is to ensure that you make adequate provision and support from for your dependents. And I pass it over to my colleagues to canvass what that means.
Yeah, so there are actually, I think putting it as means, plural, is the best way of putting it, because there are many judges that approach this based on the facts that are presented to the court. And so you see different articulations of the test in different ways. In Ontario, there's a list of about 20 factors or so, but they're not closed. They say consider all of the relevant circumstances. And that makes good sense because the circumstances are always different. There might be multiple kids under possible scenarios, multiple spouses. usually in sequence, as I mentioned. And the court will fashion a remedy as it sees appropriate in those particular circumstances. So I'll just give you examples of some of them. It's the dependent's needs and means. And obviously that changes, particularly if the support is for a child, that can change. And the court can actually revisit its orders. The jurisdiction doesn't end of the court to revisit its orders until more or to vary the initial order and reduce it. The age, health, duration, the age and health of the claimant, the duration of the relationship, financial and non-financial contributions that were made to the relationship, whether the deceased, for example, has obligations to support other people, and that may be a child from a first marriage who was special needs, and the court will obviously have to consider that. One thing in terms of how these claims work, once one dependent or purported or potential dependent brings a claim, it's deemed to be a claim on behalf of all dependents. Now, all dependents don't have to make a claim. It stops the limitation clock running because there are certain limitation periods that apply here. But that's how the court can consider all of the claims of dependents. That's not to say those other dependents are making claims. They may have done satisfactorily under the will, but the court still has to have regard. You can't just focus on the one claimant in front of the court who might be a spouse and there's minor children. And because only the spouse is claiming, you don't just look at that claim. So you look at all the circumstances. And not everybody comes on board at the same time. Some people will wait, but then they'll say, okay, no, I'm going to be a claimant as well. And that's obviously a strategic decision. The deceased circumstances at the time of death are considered. And there could be all sorts of varied circumstances. What obligations did they have? What obligations had they taken on? What was the age? At what age did they die? There's obviously the length of the cohabitation, which is more reminiscent of a family law test, but it obviously makes sense in a dependent's case as well. That's probably focused at spousal relationship because the length of relationship with the child who grows up and gets independence normally the same for everyone. It's 18 or 22 or something along those lines. The Supreme Court of Canada has talked, and the Court of Appeal Ontario has talked about moral obligations, and they're sort of, you know when you see them, but they're hard to define. And again, that arises out of the particular relationship. As an example, one spouse may have supported the other through post-secondary education or sacrificed the other one to let the other one have a career. And you can't necessarily monetize that, but there is the court will attempt to do that as best as the court can ever monetize anything, which it does every day in damages claims. That's why you see when you get into these cases, they are all case specific, but there are general principles that can be drawn from them. And as I mentioned at the outset, on the issue of inadequate support, there is some deference to be given to a testator's wishes, because there's not only one way of doing it.
Great. Well, now that we've talked a bit about who is a dependent under both of the statutes and what the courts will consider when determining whether a dependent has been provided with adequate support, let's talk about the more nuts and bolts of an actual dependent relief claim. So, John, what are the steps that occur once a dependent commences a claim?
Okay, I'm just going to start with when a dependent should commence a claim. The dependent has to commence the claim within 6 months of the will being probated. Of course, many times wills aren't probated, depending upon how the testator has left their affairs, which leaves them open to these claims for a very, very long time. But there is a limitation period, as I said, 6 months from probate, you have to commence the claim. However, the court has discretion to extend that, and it's not a very onerous test to get that extended. But if you do wait and assets have been distributed before the claim was commenced, the court's not going to be inclined to claw back those assets into the estate. It can do so in other circumstances, but the claim should be commenced within 6 months of probate to prevent assets being distributed. The claim is commenced by what's called a notice of application, which is a summary form of document. It doesn't take you don't require a lot of information in it. And then it will be supported by an affidavit, which sometimes is prepared concurrent at the same time as the notice of application, and sometimes it follows. And that's got to set out the evidence of the claimant and any other witnesses that they're relying on as the basis for the case. Appropriate parties have to be served. That is, other parties who may have claims as well, other family members. And then there'll be a responding affidavit or affidavits to respond to the claim typically. I should back up and say, as part of an applicant's claim, a great deal of the time, what they wish, as well as bringing the claim, they want information. They want information on the assets of the deceased, and if those aren't turned over, the court will order those very easily, so that everyone's got playing with the same deck. All the cards have to be face up on the table, and the courts don't like it at all when there's a refusal to disclose assets. They're not necessarily brought in for valuation purposes. There can be offshore trusts and all this sort of stuff, but the court won't have any patience for not at least seeing what those are in the structure of those assets. And so you do typically receive a request for a great deal of information. It's annoying to many executors who don't wish to deal with it. It takes a great deal of time, but the court's going to order it. And then in the responding affidavit, you set out the facts that oppose the claim, if indeed that's the position of the respondent. There's usually an opportunity to do a reply affidavit, and then there are cross-examinations on the affidavits. There'll be a requirement, at least in Toronto, for mediation. There'll be a pretrial and then a trial. That sounds like it all happens quickly. It doesn't. These cases take years to actually get to a trial. It takes a long time to put the information together, but there's just a delay in the court system, which has gotten worse, of course, during COVID. I know right now in Toronto, for example, on the estates list, if you want a 5-day trial, they're giving away dates in April, May of 2024. That's for a relatively short trial. So it does take time for these claims to unfold. For a claimant, there is the ability to get interim support while the case is working its way through the court, and there's also the ability to get interim costs, so some funding depending upon the circumstances. And the courts are sympathetic to those, as you can imagine, particularly in the case of children or in a spouse who hasn't received anything, and for whatever reason they've got a modest amount of assets in relation to the assets that comprise the estate.
Great. We can go to the next slide, please. Is there anything you wanted to add about interim support orders, John?
No, I mean, it's just a needs test, and if you can show the need, the court will order interim support. It might even order assets be liquidated to provide for that. If the assets of the estate are not liquid at the time, shares or land or what have you, the court can either order property sold or can order a charge against those property to raise money to pay. So if there's a need for support, the court will find a way to make it.
Great. And so once the litigation's commenced, how will that impact the distribution of the estate?
Okay, well, once the executors receive a copy of the notice of application, they should not be distributing any further assets.
We can go to the next slide.
Yeah, they're exposing themselves, the executors, to personal liability if they distribute assets in having received a notice of application. So there's essentially a freeze on that. You can go to the court and get an order that provides otherwise. You've got to show why it's necessary to distribute certain estate assets, and there's good reasons for doing it. Others need the money. There may be other minors who need the money from the estate who aren't making claims. There can be prejudicial tax consequences if certain payments aren't made at certain times. So you can go to court and get an order, but normally reasonable counsel on the other side will agree to exceptions. But if you can't get agreement, then the court will sort that out.
Okay, so now that we've gone through the sort of nuts and bolts of a claim, what it looks like, let's talk about how a court will actually determine how much support to order to a dependent. So John, can you tell us about that test under the Ontario legislation?
Yeah, so you can see here on the screen, these are just some of the factors. I think I mentioned that they go on, but you'll see at the top, the court shall consider all of the circumstances. These are just some of them. I would note the third bullet point from the bottom. We've touched on this before. The court considers an agreement between the deceased and the dependent, but it's a consideration, and depending on the agreement and the circumstances, it will be given more or less weight. If it's an agreement that each side has had independent legal advice on, it's going to be given a great deal of weight. If it's an agreement that appears unfair on the face of it, then it may be given, and there's no independent legal advice, it may be given little weight. At the end of the day, the court and courts, because each judge can approach it somewhat differently and consider these factors. There's factors outside of this list. They're looking to do what they think is adequate in the circumstances, and that's a range. There's no right answer to that. That's a range. Obviously, it's going to be more than what the testator thought if you get to this point, because by the time you get to this test, you've already established that support's inadequate, and so then the court will attempt to do that. But it really is considering all these factors and considering the accustomed standard of living, as you can see, that the health of the dependent, and that changes the test for adequacy of support, at least on the Ontario statute, is measured at the time of trial, not at the time of death. So circumstances can change. The circumstances of the claimant may improve. They may get remarried. That's not necessarily a factor under spousal support regimes, but in dependence relief, if they're remarried and in a settled relationship and their needs have gone down, that's certainly a factor that the court will consider more so than in a family law context, I suspect. And really what you don't see the courts doing ever is doing a breakdown of their work, $600 for this, $2,000 for that. They'll look at the numbers overall, but they'll eventually just come to an overall number. And they, again, it's not usually a matter of just adding up numbers. The court will make observations about numbers and what has been spent and what the means were. But then when you get to the final number, particularly whether it's an overall number, a lump sum, or a periodic number, you're not going to see it set out in a mathematical calculation.
Yeah, and I take your point, Jonathan, that there's a real range as to what is adequate. There is some guidance in the case law, and I think from the Supreme Court of Canada that talks about what adequacy means in the context of applications for maintenance and support. It's not subsistence living. I think, one of the things that they do look at is sort of the lifestyle that was enjoyed by the claimant during the testator's lifetime is sort of a bit of a guiding principle I've seen. So, yeah.
Next slide, please. So, Jonathan, you'll talk to us a bit about some recent case law and how the courts have determined quantum as an example.
Yeah, let me just get the Bolt case. And so the leading case in the area that Bolt cited is the Tatterin case, the Supreme Court of Canada that Karen had mentioned before. And the court looks at the legal and the moral claims. And again, Tatterin was also the case that said that you do give deference to the testator. There's no one right answer, but if you're outside of that range, then the court's going to do it from scratch. They may look at what the testator's done in comparison, but the court will redo the test. But it's those factors we looked at on the earlier slide, and there were about 5 or 6 in there. As I said, in the Ontario statute, there's 18 or 20 listed, and you consider all the circumstances. You consider the needs and the lifestyle, et cetera, of the claimant at the time of trial. You've got to consider all the other factors. Are there other beneficiaries out there who haven't made claims but have received property under the will? Because the fact of the matter is, if you take money out for a creditor, then the beneficiaries are getting less. The residuary beneficiaries at the end of the line are getting less. So you have to consider that as well. If the only other beneficiaries are adults, independent children, well, the court's not going to give that much consideration. If they're minor children, clearly the court will give that consideration. So it's difficult to state again how you come to this number by number. All you can say is that the court looks at the principles and applies the principles that it feels in the circumstances ought to be given the most weight. And that's why the list is essentially endless, because the factual matrix that comes before the court is seldom one that the court's seen before. It's just not that simple. Everyone's circumstances are different. Even in a nuanced way, the court has to do the test each time. So when you're looking at the cases, you're really looking for the approach of the court as opposed to the arithmetic of the court.
Next slide, please.
Yeah, here's look at the other dependents. Tentatively value the claims. That's not in a, I wouldn't say that's in a quantifiable way. I'd say in a qualitative way. That's usually what you see discussed. But again, there will be reference to the numbers, how much was spent in when you're looking at lifestyle test, how much was spent on vacations, where did they go, what type of hotels did they stay in, what were the types of cars, what was the type of house. You look at all of that because you need to understand the what number range you're talking about, because that does define the lifestyle. But when it comes to actually coming to the number, again, you seldom see arithmetic formula, and then you look at the non-dependent persons who may have legal or moral claims. And the balancing of the competing claims is also a very, again, that's not done arithmetically. It's done by way of a narrative.
Excellent. So it's a very nuanced area of law, and thank you both for a very interesting and fruitful discussion about it. It's obviously developing all the time. I think we do have a few minutes if we want to take one question. I think someone asked if a common law spouse can bring a claim against their partner's estate if their partner dies intestate.
Absolutely.
Yes.
This applies whether there's a will or a no will. In fact, the Act says those specific words.
Mm-hmm. I mean, it does say words. I think, like, I was thinking about the question. I think, depends really when there's an intestacy, what a spouse is generally entitled to. Where there are children of the deceased, in Alberta at least, a spouse is entitled to 50%, and the remaining children share the remaining 50%. I think that's generally a good starting point for adequate provision, unlike in a will. And so there's probably, frankly, less challenges where there's an intestacy because, speaking of legal obligations and entitlements as set out in Tattaran, generally, upon the dissolution of a marriage, a spouse is entitled to 50% of the marital estate that's acquired during the course of the marriage. So, intestacy probably leaves less room for a spouse to make a claim. But as Jonathan says, there's lots of circumstances that need to be considered in determining what is adequate in the particular circumstances of the testator's estate. And so 50% may not do it in some cases.
Yeah.
Yeah. Great. Well, subject to any comments from you two, thank you both again. And thank you all for joining us today. We certainly welcome your comments in the survey that was circulated. And for all upcoming events, please visit our website, the Fasken Institute section specifically. Thank you again and have a great weekend.
Thank you.